Welcome back. Here is video 5. Just one more to go. I hope you are finding these presentations helpful and informative. In this video, you will learn about the things you must take into account in making decisions about the future care of your children. Additionally, I talk about property and financial agreements. In a mediation about children, it is important to keep the following in mind. The needs of children are the most important consideration. Unresolved conflict in your family can be harmful for your children. Children should not be made to choose between parents. Parents can and do make the best decisions for their children. In some circumstances, it may be appropriate to have the children involved in a mediation process. Whose home is home? It's important to let children know they are wanted and loved and always have a place to call home. Things to consider when discussing the children. Where the children will live. How often will each parent see the children? What will happen during the school holidays, Christmas, birthdays, etc. How will day-to-day parenting decisions such as diet, clothing or sporting interests be managed and financed? And how will long-term parenting decisions such as future schooling be made? So in considering these issues, ask yourself, what do children need emotionally? How can you communicate effectively as parents even though you are separated? How can you ensure that the children are protected from the conflict between you, their parents? Simply consider this. Children do best when parents cooperate with each other. The following only applies to mediating parenting plans, not to property settlements or financial agreements. In the event that agreement cannot be found, or one person refuses to attend mediation regarding children's issues, then the other person may request a Section 60I certificate. With this certificate, you are able to make an application directly to the Family Court of Australia to hear your requests. Liddy is able to issue these certificates as a registered family dispute resolution practitioner with the Australian Attorney-General's Department. If you are not sure what this is about, or whether you might be eligible, give us a call and we'll explain this to you further. I've already mentioned that sometimes children may be included in the mediation process, so here's a bit more about how that happens. Sometimes children, especially older children and adolescents, like to be a part of mediation and request to have a say about their living or care arrangements. The way children are brought into mediation is via a separate child consultation. As we pride ourselves on being a child-inclusive practice, Liddy has been trained to interview children especially for this purpose. She will discuss with them what is happening and explain the mediation process to them. She also listens to any concerns they might have about what is happening at home and will feed back to the parents any particular messages the children might wish her to pass on. The only requirement here is that prior to the children being brought into mediation, both parents have given written consent for this to happen. Here are some further questions for you to consider as you separate from each other. What happens to the family home? If you decide to sell it, how will you do this? For example, who will put it on the market? What real estate agent will you use? And at what price will you set it? What will happen to the proceeds of that sale? Will one person buy the other out? Who will pay the bills and the mortgage in the interim? And what happens to your other assets, such as cars, boats, caravan or other investment properties? And how will your super or other cash assets be split? All of these are worth considering before you enter into a mediation process. There is an expectation, as well as a legal requirement, that all financial details will be disclosed in the mediation process. For a mediation regarding property, we give you a financial details form which we will ask you to complete before proceeding with mediation. We request that you complete this form and bring all relevant documents such as valuations, verifications of the assets, bank statements, etc. with you to mediation. Come to mediation with an open mind to be flexible, creative, and be open to generating as many options as possible. We recommend you seek legal advice about your situation before your actual mediation and before signing any agreement. We will inform you of the best time to do this, so you don't need to do it before your introductory session. Here are some things to consider when preparing a financial agreement. This is different from a property agreement in that it relates to the management of the ongoing costs of maintaining your family into the future. So, how will you and your partner support yourselves and the children? What will happen to joint accounts? How will you structure your ongoing costs regarding who pays for what? What will happen to the furniture and furnishings, sporting equipment, and other assets that do not have any significant monetary value? Even if you cannot make a final decision, you may be able to agree about these things at least on a temporary basis. And as well, you will need to consider what, how, and when will you tell your children, other family members and friends? What role grandparents and other family will play in their future relationship with all of you. That's it for this video. Click on video 6 to hear more about using solicitors during mediation and what happens at the end of the mediation process. Make sure you also check out our website at www.northernbeachesmediation.com.au for lots more information. And while you're there, why don't you sign up for our quarterly newsletter to be kept up to date with everything that is happening at our place.